What happens if Trump fires the Fed chair? Insights on the Supreme Court's possible response. What would happen if Trump attempted to dismiss the chair of the Federal Reserve? Last week, after a prolonged period of threats to dismiss Jerome Powell, the chair of the Federal Reserve, President Donald Trump indicated a retreat from his aggressive stance. His justification for targeting Powell revolves around alleged cost overruns and delays in the $2.5 billion renovation of the Federal Reserve's headquarters in Washington, D.C. However, a more credible reason appears to be Trump's long-standing frustration with Powell due to the Fed's unwillingness to reduce interest rates. Trump has publicly labeled Powell as a very stupid person for not lowering rates from over 4% to 1%. So, why did Trump decide to back off? One possible explanation is that the stock market experienced a downturn as his threats escalated. Alternatively, it could be that legal advisors within the White House cautioned him that such a move would likely falter in court. The New York Times reported that legal experts largely concurred that Trump could not simply fire Powell before the end of his term based solely on disagreements over monetary policy decisions. According to the Federal Reserve Act of 1913, Trump can only dismiss Powell for cause, and mishandling a renovation project does not qualify as such. While this legal interpretation is technically accurate, it overlooks the current unprecedented legal landscape. Powell is not immune to being dismissed. Trump has shown a disregard for legal constraints in the past. The pattern is evident. Whenever Trump expresses dissatisfaction with lower court rulings, he often finds support from his allies on the Supreme Court, allowing him to act as he wishes. If he were to fire Powell, they might very well support that decision as well. In fact, Trump has previously dismissed two officials without cause, violating similar statutory protections that are meant to safeguard Powell from arbitrary dismissal. The New York Times suggests that Trump's ultimate aim is to exert control over federal monetary policy. When he appealed to the Supreme Court, complaining that lower federal courts were enforcing the law regarding those officials, the conservative majority sided with him, effectively overturning a 90-year-old Supreme Court precedent that upheld the constitutionality of for cause limitations on the dismissal of certain officials. To provide some context, many government agencies have been established with restrictions on the president's ability to remove certain officials except for cause. This includes the Federal Election Commission, the Federal Trade Commission, the U.S. Postal Service, the Federal Energy Regulatory Commission, and the Consumer Product Safety Commission. The Constitution clearly outlines the President's authority to appoint principal officers, but is silent on their removal. Historically, the Court has maintained that the powers of appointment and removal are interconnected. However, in a landmark 1935 case, Humphrey's Executor v. United States, the Court ruled that Congress could impose for cause restrictions on specific employees to protect them from being dismissed for purely political reasons. The Court emphasized that the Commission must operate impartially, reflecting its nonpartisan nature. It's important to note that the validity of the for cause language is fundamentally a question of Congress's authority to legislate the creation of executive branch agencies and define their powers. In a recent ruling, Trump v. Wilcox, the Supreme Court's 6-3 majority permitted Trump to dismiss the heads of two agencies, the National Labor Relations Board and the Merit Systems Protection Board, despite his failure to adhere to similar for cause requirements mandated by federal law. The Court made this decision on an emergency basis, concluding that since the Constitution grants the executive power to the President, he may remove executive officers without cause, subject to narrow exceptions recognized by precedent. The majority claimed that they did not ultimately decide whether the firings of the NLRB and MSPB heads fell within the exceptions. However, in practical terms, those individuals lost their jobs, meaning Trump triumphed in both the immediate and broader context. This left lower courts, legal scholars, judges, and law students puzzled about the reasoning behind the Court's decision, especially given the long-standing precedent affirming the constitutionality of for cause limits on the removal of agency heads. This lack of clarity represents a troubling failure of the court to fulfill its duty to clarify the law, as established in Marbury v. Madison. Interestingly, in Wilcox, the majority acknowledged that their hasty analysis could create complications for Fed Chair Powell. Recognizing how Trump might interpret their ruling, the court stated. Finally, respondents Gwyn Wilcox and Kathy Harris argue that the issues in this case necessarily involve the constitutionality of Corps' removal protections for members of the Federal Reserve's Board of Governors or other members of the Federal Open Market Committee. We disagree. The Federal Reserve is a uniquely structured, quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. In short, this distinction is puzzling. It lacks substantive legal analysis. The NLRB and MSPB are also uniquely structured. The court's references to quasi-private and distinct historical tradition are not elaborated upon, and the relevance of the first and second banks of the United States, which were unsuccessful predecessors, remains unclear. If Trump were to dismiss Powell and the case reached the Supreme Court, it would be naive to expect the majority to firmly reject his actions based on legal requirements. The court did not do so in Wilcox, nor did it in the birthright citizenship case, despite the clear wording of the 14th Amendment. It also failed to protect migrants from deportation without due process, sending them to South Sudan, where they face potential torture or death. Given the conservative majority's history, Powell's future may not hinge on legal principles but rather on Trump's whims. Join the Bulwark Plus community and connect with over 100,000 individuals who appreciate top-notch reporting, commentary, analysis, and discussions online. Enjoy a free 30-day trial. ****